Good afternoon. Not legal advice. Like, subscribe, share, comment. Do with it as you please. Ask questions if you have questions. I was on with Alexandra Mertz and Herbert this morning talking about Elon's pay package, how it relates to legal stuff, and I wanted to address that, be a little more specific after I gave it a little more thought, and kind of explain how it fits in context. Before I start, of course, what is the definition of the word jury? 12 people who decide which client has a better attorney. And I just read that the economy in New Jersey is so bad that the mob laid off 3 judges. Anyway, I wanted to kind of explain in context how the Elon pay package impacts legal proceedings, because there's an ongoing proceeding in Delaware, along with a potential appeal. And the pay package that was rescinded by the court, that's the subject of what we're talking about, related back to 2018. And the issue is when you have what Delaware deems a controlling shareholder, they are required to demonstrate absolute fairness throughout a transaction. And not only that, the burden of proof gets flipped. So that's really difficult for someone in Elon's position, as it was determined, to withstand that standard. So what's the exception to that is if you got shareholder approval, that would override basically any defects or any inability to show overall fairness. And in 2018, or on or about 2018, I think more than 73% voted in favor of the pay package. Because it was deemed that not all disclosures were provided prior to the shareholder vote, somebody sued, and the court in Delaware in this ongoing matter agreed and rescinded the pay package. So in essence, Elon has no pay package going back to 2018. Now, as of today, a proxy statement went out, and it appears, more than appears, that Tesla is going to basically repeat that same pay package back to the 2018 period in Delaware. And obviously, there's a question about why not in Texas, why in Delaware, and I think it'll become apparent in some respects that it relates to this ongoing case. But the issue is that now there is a proxy, and the proxy has approximately 450 pages, the preliminary proxy statement, and there's a bunch of attachments, including the decision of Judge McCormick against Elon in Delaware in the court, along with some other stuff. And I'm sure there's going to be additional materials that are going to be added, and the more the merrier. When I discussed this earlier months ago, we talked about loading it up with negative stuff so that if there's a future vote and shareholders approve it, you can't say that they didn't know. And it would put the plaintiff in a difficult position. So there is a ongoing case that's now in Delaware, and after the decision to rescind the pay plan, the question that remains is the attorney's fees. And there has been motion that was filed to ask for a certain amount of attorney's fees based upon shares directed at Tesla that added up to approximately $6 billion at the time it was requested, which would be the largest attorney fee award in the history, maybe in the world, but in the United States, that's for sure. And Tesla will have an opportunity to respond to that on May 31st. Then plaintiff will have an opportunity to reply to that on or about June 30th. Judge will rule on that probably end of July or in August. Tesla, since they've already indicated an intention to, will appeal, although it could be resolved depending on what the numbers are. But, anything can be resolved. But at the current time, they'll appeal, and that appeal probably is September, and you could figure 10 to 12 months before you get a resolution of that particular appeal. So what happens, though, if their pay package is approved? So the pay package is going to be voted upon June 13th. And as I indicated, May 31st, there's a brief that's going to be filed by Tesla as to the attorney's fees in the case in Delaware. And that brief, I'm sure, will indicate and illustrate how valuable Elon has been to Tesla and how overreaching the award would be to provide the attorney's fees to the plaintiff's attorneys in anywhere near the amount of $6 billion. I'm sure that's going to be in there. And I'm sure that will be very helpful in terms of, because it's going to be public and because people like me and many, many others will discuss it and all the various benefits that Elon brings to Tesla. So that will be public. I think that will encourage the vote and encourage the vote to be even stronger, or at least equal to the vote in 2018. So let's assume it's passed in June 13th and the pay package is now reinstated, subject to now with full disclosure to the shareholders, because now they got hundreds of pages of materials that beats up Elon, but they still give it to him. So what happens? Why do you need to go forward with the appeal? What's the purpose? The reason we have to go forward with the appeal is because of the attorney's fee award, what that will turn out to be. Because even if the underlying pay package issue is resolved, which normally would end the case, right? Because if there was no attorney's fees at issue and Tesla reapproved the pay package for Elon and we're back at square one, then we could just move on. There would be no necessity for an appeal, because a trial court's decision is not precedent. It's the appellate courts that make law. So it has to go up on the Court of Appeal to be established as appellate precedents that could be cited by attorneys like me or anyone else. So just a decision by a trial court, I mean, it's not, you don't like it, but it's a decision. But if you let an appellate court make law, then it impacts many more cases. So if there weren't attorney's fees, I think after Tesla or shareholders approved the pay plan, the new one for the old period, I think ordinarily Tesla would just drop the appeal and move on. But here there's a big attorney's fee issue, and they can't just move on because $6 billion of fees in some fashion, and it was chosen in stock as opposed to money, could have been maybe backed by insurance, but it's not done that way because of the way it's requested, which of course will be an issue. But that's still hanging out there. So if any substantial award that's not resolvable, I think it has to go up on appeal. If it goes up on appeal, the appellate courts are different than trial courts. They don't try things. They accept the facts as presented generally. What they do is look for errors of law. And if there's errors of law or misapplications of law, that's where they get involved. But if there's no reason for them to get involved, they don't like to get involved for various reasons. That's kind of the policy. But also sometimes they're not the most diligent people in the world. So if they don't have to work, then why work? So in this case, if they found out there was a resolution of the underlying share plan, which I'm sure will be challenged in suit in the future anyway, but will be subject to now full disclosure, so it'll be tougher to attack it. But if it's replaced so that the new plan is replaced, so the 2018 plan is now in place, the appellate court's going to feel like, why are we even deciding this case? So it's likely that by filing and requesting the pay plan now, that it will influence the appellate court in thinking to some degree that the decision is moot, and also will be used, I think, as a factor to establish that there's no financial benefit that's been derived by the actions of plaintiff's counsel. In essence, what happens if the original pay package that they got rid of, rescinded, comes back? What benefit have they provided to Tesla shareholders, to Tesla, to anyone? If that's the case, I think it's a difficult argument for them to show substantial value. And because of that, and because of the pay plan being in place, at worst, I think it will reduce the amount of any attorney fee award. Now, the other part is the reason you have to appeal if there's a judgment for attorney's fees is once you appeal and get a bond or otherwise, you can stop collection efforts. So let's just say, for the sake of discussion, they got a judgment for $1 billion worth of shares. If you didn't appeal, get a bond, they could try to collect and obtain those shares and perhaps dispose of them. If you have a bond, or depending on other manner in which you're able to get a stay on appeal, they can't collect on that until the end of the case. So it's most likely that whatever the attorney fee award, there would need to be a bond that would stop any further action, and nothing else would occur until the end of the appellate case. So I think it was brilliant strategy, in effect, to put out the share plan, presuming it's passed, because I think it really does isolate the trial judge and puts the appellate court in a position where their instinct is going to be they're deciding a moot case. And it will, in my opinion, it will influence them in favor of Tesla. Not that they're going to rule necessarily in favor of Tesla with regard to attorney's fees, but I think they will lessen any award. Because in effect, it will be evidence of no benefit to the shareholders. So with that in mind, I think the next step will be to look at the briefs and we'll discuss them. In the interim, I'm sure the proxy materials will go out, and I'm sure that the trial judge will be reviewing all those materials. And again, after there is a decision, since it's still in Delaware, this pay package will still be in Delaware. It will still be subject to scrutiny. But again, the difference will be it'll be subject to scrutiny. In other words, somebody could go in and challenge it, but it'll have been fully disclosed to shareholders. So the argument will be much weaker, and the likelihood of a plaintiff prevailing in the future will be less, or much less. And I think it's important that the vote total be at least as much as in the past, whatever it was. If it was 70, I think it was 73% or more, because again, that will establish with the full disclosure that the shareholders would vote in favor of Tesla, or Elon in this case. So I hope that provides clarity as to what's going on, the reason why an appeal needs to go forward to attack the attorney's fee award, the reason why perhaps the pay plan was presented to kind of undercut plaintiff's attorney fee argument, and to be able to make the appellate court feel in part that what they're doing is really unnecessary. And I think that all good strategy. I would expect the proxy to be accepted by a large majority of shareholders. I expect Elon's pay package to be reinstated, and it'll be interesting to see how future attacks come about, because I know that Tesla will be moving, or most likely moving, to Texas anyway. But it'll be interesting to see how a future attack is dealt with. And it'll also be interesting to see if Judge McCormick or other judges similarly aligned will be still on the bench when any future attack is. And also, it may be the case that if someone in the future filed a action involving Elon's pay package, that Elon and his counsel would move to disqualify Judge McCormick if she was again going to be on the bench, especially if any attorney's fee award was substantially reduced based upon a claim of bias. And, there are some methods, I don't know in Delaware, but in California, if I go to court, I get like one free opportunity to get rid of a judge for any purpose. This is an appellate, this is a trial court judge in Delaware, so I don't know how it goes, but there may be ability in the future to not have her judge any Elon's case, even if it's a repetition of this. And she will not have an opportunity to interfere with the appellate court unless the appellate court sends the case back for review to the trial court. So what could happen is, on this appeal, if the court finds that the attorney's fee award that was made by Judge McCormick was improper, either excessive or inadequate, as opposed to just putting in a number, the appellate court often will just send it back to the trial court, and the trial court will recalculate a number subject to that the appellate court sent it back and said you didn't do a good job. So that could happen too. If that happens, then she'd have an opportunity to provide further information and influence. If not, she won't see this case again, and the appellate court will make that decision. So hopefully that makes sense. Hopefully that you understand now why there's the need to go forward on the appeal, and hopefully understand the benefits of some of the strategic moves that I think were undertaken by counsel for Elon in order to undercut plaintiff's counsel's request for what I deem exorbitant attorney's fees. Anyway, be well, take care. Hopefully this added some clarity for you. And if you have questions, please comment, and I will try to answer any question in some reasonable fashion. Take care. Have a great day.